Good
Have they
evening.
updated you with a Mac, have they, John?
Yes, yeah, that's right. No, I've just gone to a new Microsoft Surface Book, so I'm just learning how to control that. So this is Laws 12062. It's alternative dispute resolution. We're into week 8. We're dealing with statutory dispute resolution schemes. We need to listen very carefully tonight because there may be some hints for our second assessment piece. Now, speaking of assessment, the work that you've all been doing for the first assessment is due tonight for those of you that are looking at this on the 8th of September 2016. And I'm sure looking at Moodle that most of you have submitted your work already. Thank you for doing so. I hope you have had fun with that. I will do most of the marking over the weekend and Monday, and I'll have the results released to you by next Sunday. So that's about 9 days' time. If you haven't submitted your work and you're watching this video before the final cut-off date, please submit your work as soon as you can. And of course, you will lose 5% per day for late submission. But so the message is the sooner the better. Bear in mind, of course, that once we reach that final cut-off date, which is Saturday week, then I won't accept any further work, and it'll be a nil assessment. So let's hope that doesn't apply. Are there any questions from anyone about that first assessment? I haven't cut off the submission, so I need to be a little vague, I guess, about responding to that. No questions? All good? All right. Well, once again, thank you. We've got a number of people have joined us, so I really appreciate that. And as usual, if there are any questions, please ask by unmuting your microphone and asking the question, or using the chat facility. And of course, the discussions should go beyond tonight in terms of discussions on UCrew. Thank you for contributions that have been made lately on UCrew. I really appreciate that. Now, one thing I will appreciate is if you could provide some feedback. Next week is feedback week. It's an opportunity for you to raise any problems, to provide some feedback. On UCrew, I'll be inviting comments. If there are any suggestions, if there are any issues, please let me know. In addition to that, in the public forum, there is, of course, and I'm sure by now you're familiar with it, the big red button on the top left-hand side of Moodle, and from that you can provide your feedback. And certainly I would appreciate it, the university appreciates it, and it's all confidential. So please feel free to provide some honest feedback in that regard. I am very keen to ensure that this course is something that is relevant and useful to you in a number of ways. So if you believe that you're not obtaining the knowledge or the skills that you'd hoped to obtain, please let me know, or provide that feedback anonymously through the feedback device. Right, are there any questions about feedback week? What I hope to achieve, what I hope to receive? All good? Okay. Now, when it comes to preparing for the second assessment piece, I want you to initially consider the presentation of your paper. I want you to consider my sample document, for example, and many of you would have seen that. If you haven't, I urge you to do so. We're in second year equivalent, so I expect work to be at a certain level. I don't want to be talking about the fact that a particular case, if cited, needs to be italicised, or legislation needs to be italicised. We should be well beyond that. So have a look at my sample document. That will provide you with some guidance as to what I believe is relevant in a professionally presented paper. So please do that. I won't go through in any detail. I'll leave you to do that for yourself. But if there are any questions, please ask through UCrew. If you feel that it's not appropriate for UCrew, then ask me privately. But I think you all know that I prefer to have questions asked through UCrew so that everyone has the benefit of both hearing my response, as it were, or reading my response, but more importantly, everyone has an opportunity to contribute. And some of the material that is presented by students is absolutely brilliant. So you have the benefit of working with each other online if you provide your question and your response through UCrew. All right, so please consider my sample document before you start to embrace the second assessment piece. All right, so court-based, statutory-based ADR processes. I'm sure that you've all read the chapter in the text that deals with this issue. And what you would have noticed is that courts have a wide range of available options. Tribunals do as well. And when you're considering the options, you need to consider it from two perspectives. The first is the perspective of you as a legal advisor providing advice to a potential client. And the second is you as a potential ADR practitioner asking yourself, how do I become one of these mediators, case appraisers, adjudicators, whatever it might be, because that might be of interest to me for a living. So the first hint, which I've already given last week and the week before probably, is that the second assessment piece may be couched from the perspective of you being an advisor to parties in a dispute, or you being a potential ADR practitioner, and I want to know how you do it, how you register, where you might find your work, how you might help people, things of that nature. Or it could be a combination of the two. So are there any questions about what I'm asking you to do while you're doing your reading and the way in which I want you to do the reading? Does that make sense, what I've just tried to explain? Are we all good? I can see thumbnails. I can't see many people, but I'll take it as a yes. We're right? Okay. All right, thank you. So you would have seen that courts have procedures, tribunals have procedures. There is ADR process both at a federal and a state level, and of course all the states. And the third dichotomy is that some of these things are compulsory and some of the procedures are voluntary. So you need to consider those differences in the context of any dispute. Now, if, as I've earmarked, is likely to be the case, the second assessment piece is practical in nature, and if it relates to, the sample document should be on the front page of Moodle, but if anyone has trouble, I'll make a note to post it on uCrew as well. So just the first thing we need to do is consider whether the dispute we're talking about is federal or state. Because if we can't work that out, then we're going to give advice which is incorrect about the appropriate ADR procedure. So I hope you can understand that basic distinction. We then need to consider whether it's a referral from a court or voluntary. And if you're dealing with a dispute situation, it's not necessarily going to be the case that someone has a ready-made answer for you. In other words, you need to be proactive. And to be proactive, you need to know where you might go to attempt to resolve the dispute or to assist the parties in resolving the dispute. And if you embark on a certain process, you then need to ask yourself, am I potentially leading my client the wrong direction because there may be some compulsory requirements if the matter becomes litigious and I don't want to waste costs, if you like, by duplicating an ADR process. And thank you, Jessica. The sample document is near the end of the home message on Moodle, so thank you. All right, so the starting point, it seems to me, is probably to draw some flowcharts or at least have a document where you draw the relevant sections of different ADR provisions and you catalogue them in a way that makes sense to you. So let's take an example. We're dealing with a family law dispute. One would think that we're now talking federal, and if we're talking federal, we've then got to think about what is the legislation that applies, what are the rules that apply, what are the practice directions that apply to that particular dispute, and once we've armed ourselves with the source material, we extract the relevant parts of that material into a document or a flowchart or something that makes sense to you, so that you have at your disposal something that provides you with an overview of the ADR process, court-based process, if you like, for that particular dispute in question. So that's family law, that's federal. But you need to consider that from different perspectives as well. It might be a different type of federal dispute, in which case you've got to ask yourself, what legislation do I need to consider? And you'll be thinking, of course, the federal legislation that would be relevant in those circumstances. Okay, I've been doing a lot of talking. Are there any questions? Have I thrown you or helped you? I'd rather help you. And
I got a sort of a question, John.
Yes. Yes, Terry.
Yeah, just on that point, I was looking at the Civil Proceedings Act the other day, and Part 6 is the ADR processes, and it says that parties can agree to the process or the court may refer the dispute. So the Part 5 is about conferences, and all it says there is a conference held at, it means a conference held at the court's direction. So can you just clarify a bit between when the court can decide to go to have a directions conference as opposed to when Part 6, the ADR process, kicks in?
Yeah, okay, so we're talking the Civil Disputes Resolution Act, 2001. Is that what you're talking, federal, or you're talking state?
No, Civil Proceedings Act 2011.
Okay, all right. So that's the federal legislation.
Queensland.
Okay, all right. Well, I might just
No, Queensland Civil
legislation.
Proceedings.
Okay, because we do have the federal legislation as well in that regard. Okay, the important thing to bear in mind is that we need to consider usually several pieces of legislation and several different rules that might apply. So in the Queensland situation, bear in mind also the provisions of the UCPR, the Uniform Civil Procedure Rules for 1999, and Part 4 of that provides for the ADR process as well. So, and this is the hard part, you're thinking, well, where do I go for this particular dispute? And that's really the point of tonight's exercise, so that you can start to map that out. So I'm actually going to start with the UCPR provisions, 1999, and Part 4. Have a look at Rule 319, where the registrar may give notice of a referral of a proposed reference to ADR process. Rule 323 provides for referral of the dispute to an appointed mediator. Rule 324 provides for the time period for conduct of the mediation, and Rules 329 and 331 essentially require the mediator to comply with certain obligations to fulfill work. Rule 334 provides for referral of the dispute to a case appraiser, and the case appraiser have certain powers of the court, and Rule 343 provides that a party dissatisfied with the case appraiser's decision may elect to have the dispute go to trial. So in that context, we're dealing with the UCPR provisions, and you're quite right, you need to tie that in with other relevant legislation as well. And it becomes a bit of a minefield. What I'd suggest is that the starting point would be to have a look at websites, see if there's some useful information there, flowcharts, summaries that tie it all in together. And if you find something that's of great benefit, then feel free to share that with classmates. Now, I think, Terry, what you were saying is how does the registrar decide which way it should go? Because registrars have power for mediation, they also have power for case appraisal. And I think in many ways, the submissions of the parties and the way in which the parties wish to guide the matter has a great bearing on this, because you can push for a certain procedure, perhaps make it easy for the registrar or the court to make a decision in a certain way. I know that's a long answer question. Long answer to your question, Terry. Does that provide some guidance?
Sorry, John, you just faded out there towards the end. No, that's good. I was just having, under that UCPR, I was just having a look at the different forms that you have to use depending on whether it's a referring order from the court or whether it's a consent order from the parties. And then that led me to those, the mediator's certificate or the case appraiser's certificate. So we've got to keep those sort of things in mind when we're looking at the assignment.
Absolutely. And in the assignment, I'll be inviting you to be very proactive about this. And it may be that your requirement in the assignment is to map out a certain course, perhaps with different flowcharts depending on circumstances that might arise. So when you're reading this material, bear in mind that the assignment won't ask you to name the 3 powers of a registrar under the UCPR. It will be a case of you being given a scenario. This is not, if it's a case of you advising a client, you'll be given a scenario and you then have to identify what might apply, why you would apply it, and then provide some practical advice on how much it might cost, who does the job, how long does it take, things of that nature. So it is a matter of reading the material really actively and think to yourself, well, when would that apply? How would that apply? How does it happen? If I'm the lawyer involved and I see merit in mediation as opposed to case appraisal, how can I guide the matter towards mediation? And that might be, creating some arguments and submissions to help. The other thing that it might be is it might be that you're required to give thought to the question as to how you would become a case appraiser and how would you obtain work as a case appraiser under the UCPR by receiving nomination from a registrar to be the case appraiser for a certain case. So how would you go about that process? That's the other avenue to what the practical assessment might be. Am I on track, Terry?
Yeah, mate, all good, thank you.
Okay, thank you. All right, so bear in mind also that we've got the federal sphere. So it may not be just a matter of considering the state legislation. Any scenario that you may have in the second assessment could embrace the federal court situation. So if you're thinking it from a federal perspective, what I'd like you to do is have a look at certain parts of the Federal Court Rules, 2011. In particular, you need to consider the Rule 8.02 and the Civil Dispute Resolution Act. Have a look at sections 3, 6, 7, 8, 9, 11 and 12. That's of the Commonwealth Civil Disputes Resolution Act of 2011. I'd also like you to look at the Federal Court of Australia Act and give some time and thought to section or part V, as in 5, Roman V, B, which deals with case management in civil proceedings. And in particular, I'd like you to look at sections 37M, 37N, and 37P. This is all of the Federal Court of Australia Act, 1976. And ask yourself, how do those overarching provisions fit within the ADR scenario? Then in a federal sphere, have a look at the Federal Circuit Court Rules of 2011, and you'll note that those rules will apply. So if those rules are insufficient, then rules made under the Family Law Act or the Federal Circuit Court will apply. And finally, have a look at the Family Law Act 1975, and in particular, have a look at Section 60I, subsection 7, and you'll see that's the provision where a court is not permitted to hear an application for an order about children unless there is a valid certificate confirming a dispute resolution has been attempted and a certificate obtained. So they're the things that I'd like you to look at.
Sorry, John, excuse me.
Yes, Jason?
Would you mind just repeating that section for the Family Law Act? It went all funny, the internet connection.
Oh, sorry. Yeah, it's a really bad line, and I've only so it was Section 60I(7) of the Family Law Act. Okay. Apart from that, I'd like you to look at QCAT, and of course I'm a member there. Have a look at some of the overall obligations for QCAT dispute resolution. And apart from that, in the federal sphere, you would see some commentary on the Administrative Appeals Tribunal Act, and have a look at Section 3, and it defines dispute resolution as, now this is a long list: conferencing, mediation, neutral evaluation, case appraisal, conciliation, or other procedures, but does not include arbitration. So all of these things have different ways of looking at, all of these pieces of legislation, both state and federal, have different ways of looking at the ADR procedures. And that is probably all I want to cover tonight. I know it's a short session, but if I can leave you with these thoughts: when you're considering a dispute scenario, number one, ask yourself, is this federal or state? Number two, ask yourself what rules apply, and particularly what mandatory requirements there might be for resolving a dispute. And then number three, think about whether you should invite your client to consider something that is voluntary or something that is court imposed in terms of resolving that dispute. Are there any questions before we wrap up? And I thank you for your patience. I've been doing a lot of talking.
One quick one, John.
Yes, Terry?
Now I got a quick one, John. I'm just curious, this goes back to last week though. QCAT hybrid hearings, the text seem to sort of be a little bit 50-50 on what people think of them. What's your thoughts on them?
I think they're very good in certain cases. So, for example, it might be a tree dispute or a dog dispute, and I think where there's some degree of urgency, and also the parties want to get it resolved pretty quickly. I did one last week, a hybrid hearing, and the parties made a genuine attempt to settle the matter after I'd heard the matter. Didn't settle, but at least they made a genuine attempt. So I'm a fan of them. Hope that answers your question, Terry.
Yeah. So in a case like that one you just referred to, you'd made a decision, but you let them go to mediation. They couldn't resolve it, so your decision stood.
That's it.
Is that how it worked?
Yeah. So what happens is that we hear the matter just as a normal matter. At the conclusion of the matter, I indicate to the parties that I need 5 or 10 minutes to write my decision, which I then do. I invite the parties to come back in. I somewhat ceremoniously then declare that this is the decision, fold it, put it in a sealed envelope, hand that to my support officer, and then go into mediation mode. But it's a very pure form of mediation. I don't provide any suggestions, hints, anything of that nature, because I've already heard the matter and made a decision. But just give the parties one last opportunity to attempt to resolve it. So really you're just facilitating in a very pure manner. That process may last 15 minutes, it may last a half an hour. But if the matter is resolved by consent, I can then make an order to that effect. If the matter is not resolved by consent, we then, I usually go outside for the mediation part. I come back in, we take our seats. I then read the order that's made and the reasons, brief reasons for making the order, and that concludes the matter. So that's the hybrid hearing process.
Okay, and it's at your discretion as to whether you think the parties look like they may be able to come to a solution themselves. Is that,
Yeah.
you'd obviously hear a matter where you'd think these guys are never going to agree.
Oh yeah, you use your discretion. It may be that after 10 minutes we're not getting anywhere, so we'll reconvene. The parties usually make that clear to me, but sometimes it may go on for half an hour and they might be making a really genuine attempt. Sometimes it settles.
Okay, thank you.
Thank you. All right. Okay, so during the week, let's share our thoughts on UCREW. I'll get that assessment marked back to you by the end of next week, and next week we'll go on to the next chapter. Okay, so I'll end the recording at this stage, and all the best, and we'll see you next week. Bye.